Hello, I'm Clarence Anthony, CEO and Executive Director of the National League of Cities, and welcome to another episode of CitiesSpeak. For 100 years, NLC has been advocating on behalf of local governments at the federal level, and increasingly have been seeing how the rulings of federal courts impact cities, towns, and villages. So it's with this in mind that we teamed up with NACO and IMLA to create the Local Government Legal Center. And already we're making a big impact, ensuring local leaders' voices are heard by the U.S. Supreme Court. Now, this past term was memorable. The Supreme Court wrapped up in July, and their decisions will have big impact for cities, towns, and villages in America. So we decided that we need to have a conversation about it. And we have the perfect guest, Amanda Karras, the Executive Director and General Counsel of the International Municipal Lawyers Association. Amanda oversees IMLA's legal advocacy efforts with the Supreme Court, circuit courts, and state appellate courts. She also authored numerous amicus briefs, including at the Supreme Court merits and petition stage, as well as in federal circuit courts. In addition, to hear her previous experience in private practice, as well as, most importantly, Amanda has been a strong partner to NLC with our ongoing legal advocates update. Amanda, welcome to CitiesSpeak. And you have a tall order today to explain really what has happened, what may happen, and just tell us the implications.
Thank you so much for having me here, Clarence. I'm excited to talk with you and your listeners today.
For those who may not be aware, can you talk about the Local Government Legal Center and what it is and how you're working closely with NLC and NACO to make sure we have a voice before the Supreme Court?
As you mentioned, NLC, NACO, and IMLA founded the Local Government Legal Center, and then the Government Finance Officers Association is an associate member. And through our collaboration, we combine our voices to provide effective and persuasive advocacy at the Supreme Court on behalf of cities and counties and towns around the country. You know, let's face it, the Supreme Court justices are incredibly smart. But none of them have a background in local government. And so, we find that our role at the LGLC is to educate the court on how particular cases are going to impact local governments. And then in some cases, we're also educating them on how aspects of local governance works, things that your listeners know a lot about. So while we're doing that, we're also, as you said, educating our members through webinars and blog posts and presentations. And I think it's really exciting work and important work. And I appreciate the opportunity to collaborate with NLC on it.
Well, thank you very much, because we do need a professional that truly understands local government and the impact that those cases could have on us. So let me jump right in. One of the major cases that the Supreme Court took up this term was the Grants Pass versus Johnson case. And it's got a lot of media attention because it deals with the very important topic that most communities are dealing with today, and that is the homeless, unhoused population. But for NLC, this case came down to the issue of local authority and the ability for local officials to make decisions on behalf of their community. Talk to us about that, because it can be complex for those who don't understand the role of local government and how we lead our communities.
You hit the nail on the head here. This case was really about local authority and local control. I think I'll just say at the outset, and I know your listeners know this better than most, and I'm sure you'll agree, and you may have already said it, homelessness is a really complex societal issue. Especially when we look at how many factors contribute to it. And I know your members and other local government officials around the country are working really admirably to address these issues. They're coming up with creative solutions. They're expending significant time, money, and resources, all with the aim of trying to support individuals experiencing homelessness and to try to alleviate this crisis, as you said. So talking about the case that the court had, I think it's just important to have that context, because I know for NLC and IMLA, we really did have that in mind as we were looking at this. But this had a very specific legal issue. And so let me tell you a little bit about the case and then kind of circle back to that local authority piece. So the case involved a city in called Grants Pass. It's a city in Oregon, population about 38,000 people. And there were about 600 individuals in the city who were experiencing homelessness. So to understand this case, we have to travel back in time to 2019, when the Ninth Circuit decided Martin versus Boise. And this is a case that, even though it was at the circuit court level, I think a lot of local government officials, especially out west, which is where the Ninth Circuit is located, they really were familiar with this decision. So the Martin case involved an ordinance in Boise, Idaho, that made it a misdemeanor to use streets, sidewalks, and parks or public places for camping. So it was a public camping ban, basically. And back in 2019, the Ninth Circuit said that the Eighth Amendment's cruel and unusual punishment clause prohibited the imposition of criminal penalties for this activity, sitting, sleeping, or lying outside, when individuals were homeless and had no alternative access to shelter. So that was the rule in the Ninth Circuit, which again covers, I think it's something like 20% of the US population out west. It's the biggest circuit in terms of population. So now we move back to present time or near present time to the Grants Pass case. And here, after the Martin decision, Grants Pass passed several ordinances which, taken together, essentially made it impossible to sleep outside without any form of additional shelter. So they didn't prohibit sleeping outside, but they said you can't have encampments and you can't publicly camp, which was essentially having shelter on public land. And these were fine-based ordinances, although eventually it could escalate to a criminal trespass. So we had a lawsuit. Two homeless individuals sued the city. They made it a class action. And what that means is they were suing on behalf of all of the homeless individuals in Grants Pass. And the Ninth Circuit ultimately said, yes, this ordinance also violates the cruel and unusual punishment clause, and it certified the class. So it said you can bring this on behalf of everybody experiencing homelessness. And the reason was there was no alternative forms of shelter available in the city. So that was the crux of the holding. So at this point, what we saw was a groundswell of support from cities, counties, states, and public officials asking the Supreme Court to take this case. And I'm going to circle back to this, but I think it's important to explain why. Part of the problem with these decisions, they sound pretty reasonable on their face. And I know we have a lot of listeners who are really passionate homeless rights advocates, and we certainly understand that. I think the problem was the unworkability of these rules for cities and how they were playing out in the lower courts, tying their hands, the inability to clear encampments that were dangerous and things like that. So the Supreme Court ultimately agreed to hear the case, and on one of the last days of the term, ruled in favor of the city, concluding that the Eighth Amendment's cruel and unusual punishment clause is really meant to address the method or kind of punishment. It's not meant to address what you can criminalize. And they talked about the idea that at founding, when they put the Eighth Amendment into the Constitution, they were really looking at sort of barbaric practices that were happening in England. And so cruel and unusual punishment was really referring to that. And here what we had was fines and 30 days in jail. And so that is just not cruel and unusual according to the court. The court did say, both the majority and the dissent, look, this is about this particular clause in the Constitution. It's not about other clauses. So it's certainly possible there could be other challenges in the future. But for the Eighth Amendment claim that was brought, that was the end of the matter. Now, I think what was really interesting about this decision is how it relied on amicus briefs, including the LGLC brief. And our brief was cited something like 18 times by the Supreme Court. And what that told me was the court was listening to cities here. The court was understanding that the local leaders are the ones on the front lines addressing the homelessness crisis. And our point in the brief, as you said at the outset, is this was about local control. And these are difficult issues. And we explained in the brief how the rulings had really tied the hands of local leaders. And I'll just give a couple of quick examples. We saw um, examples in the Ninth Circuit of lower courts issuing injunctions preventing cities from cleaning encampments when they didn't have enough shelter beds, even if they offered shelter to the individuals in that encampment. And the ruling said, well, but you don't have enough shelter for everybody. And so I think that made people sort of scratch their heads a little bit. We also saw some situations, where if you really take the rulings on their face, the Ninth Circuit rulings, that is, you could say, well, they're incentivizing cities to build temporary shelters in order to be able to enforce these laws and to clear encampments. And a lot of, I think, cities think the gold standard is permanent supportive housing with wraparound services. And I think what's right for one city may be not right for another. But the point here is that should be up to the cities and not the federal courts. And what was really gratifying here was the Supreme Court understood that and basically told the federal courts that they need to stay out of this policy area, and that this is a policy area that local leaders need to figure out. And now it's up to the hard work of those local leaders, and they know they're up to the task, and they're going to really dig in now and work to help alleviate this crisis.
Yeah, I appreciate your focus on, one size does not fit all. One solution in one community may not fit in another community. Also, the notion that local leaders really do want to deal with the tough issues that they are elected or hired to address, but they need the flexibility to be able to do that. In this case, really does provide them with the authority to manage, create solutions that fit their community, fit the challenge that they're having. And they're up to addressing the issue because they have to. Because if they don't, they're going to see these folks in the grocery store, church, or anywhere in the community, and they're going to ask the question, how are you addressing those issues? And why are you not addressing whatever the issue is? And encampments is one of the things that city leaders need, that flexibility to be able to address the issue based upon what is needed within their communities without, I would say, guardrails provided by the Supreme Court or Congress, because local issues are there for local decision makers to address. I want to switch to another case that probably everybody would be interested in, because all of us every day use what we call social media to communicate with our job, communicate with our family members, any of our networks. So the court took up a case, the question of social media usage by local officials. And when this is considered a state action, in the case of, what is it, Lemke versus Freed, I think every municipal leader became concerned because they communicate with their constituents, but they also communicate with other networks. But they do it sometimes on their personal networks as well. What do local leaders need to know about this case to avoid litigation, first of all? But also, how do they use it in a way that really separates my personal texts around my personal thoughts compared to the role I have as a municipal leader? I know that's very complex, and I've tried to explain it to our members as in my role, but I think you can do better than that, Amanda.
Well, I don't know if I can do better, but I'll give it a shot. And it's absolutely complex. You hit the nail on the head again. And this is a case. Everybody uses social media, including the 20 million state and local government employees, right? So this was really important to our members, I know, to NLC's members. And the question, as you said, is where is that line? And when somebody's using social media in their government employee, when are they wearing their sort of private citizen hat, and when are they wearing their government official hat? And if they're wearing their government official hat, that means the First Amendment applies, right? And so that's really what we're talking about here. So in this case, just briefly, it was interesting. We had a city manager front and center. So, local government official who was at issue in this case. And he was using his Facebook page in a pretty mixed way. And I think that's how these cases come up in a lot of context. He was posting about his dog and his kids and the food he likes to eat, all the things we like to post on social media, right? But he was also posting about his work as city manager and city business and the city's COVID-19 policies. This all came to a head during the sort of COVID crisis. And so we had a citizen who would post things in response to his, and I guess the city manager didn't appreciate what he was saying a lot of the time. And so at first, the city manager deleted those comments, but eventually he blocked this citizen from this account. And again, I think this is really common, and this is how these cases get litigated. And it's important that the Supreme Court stepped in to tell us and to give us some guidance here. So I think that local officials can better understand where that line is. So the court held that a government official's social media posts will be attributable to the state, and therefore the First Amendment will apply only if the official possessed the actual authority to speak on the state's behalf, or in this case, the local government's behalf, on the particular issue. So that part's important. And the government official had to be purporting to exercise that authority when they spoke on social media in the particular instance. So kind of circling back to your question, how do we avoid liability in this area? I think the thing I would want to impart to listeners the most is the gold standard, I think, is still pretty clear, and that's separate accounts. But I know that's also hard. But let me just say that at the outset. I think if we can do separate accounts, that's how we're going to ultimately avoid liability in all of these instances. For elected officials, that means 3 accounts. That means a personal account, a government account, and then a campaign account. When you're campaigning for office. For all other public officials, it's probably 2 accounts, a government account and a private account. Of course, if they want to have more private accounts, that's fine too. So I did want to just underscore that's the best way to avoid liability, but I know that that's not always what folks are looking for. And I think the Supreme Court did ultimately recognize that government officials have their own First Amendment rights. And so we can't tell them you must have separate accounts, right? The Supreme Court couldn't do that. So with that sort of caution, I'll give a little bit of the guidance from the court as far as how we deal with these mixed usage cases. So the first thing the court said is the use of disclaimers is going to carry a heavy, though not irrebuttable, presumption that this is a private page. So, if I put up there, I'm a government official, and I say this is the personal page of Amanda Karras, and it does not necessarily represent the views of City X.
I think that's especially given this time of political campaigns and other things is going on. I hear municipal leaders kind of say, or elected leaders saying, I'm speaking as, Amanda Karras, not as Mayor Karras. And so is that enough of a disclaimer? And I want to endorse this person, or I am supporting this constitutional amendment or proposition in a city. Is that enough to distinguish your role?
Again, they said it's going to carry a presumption, but it's not going to be enough to be a slam dunk all the time, is the way I read the decision. It's going to tip the scales in favor of it being a private account, but they're still going to look at overall how it's being used. And are you saying that? But then, for example, are you the mayor putting something out on your social media account where it's the only place that somebody can access that information? And so in that scenario, I think the scales would tip in favor of it being a government account. The court says if the only place somebody can access this information is your so-called personal account, well, that can't be personal, right? So I think in that scenario, what we would tell the mayor and the other elected officials is, let's repost that, right? So let's let the city post the policy, and then you can repost it onto your personal account that has the disclaimer. And I think that'll help. The other thing I think the court told us is let's avoid using any sort of government resources on so-called personal accounts, right? Because if we find out that government staff and government funds are being somehow used to help support this particular social media activity, that's again going to weigh in favor of it looking pretty governmental in nature. And so, your chief of staff or folks like that, communications people, if it's a personal account, they shouldn't be the ones posting things on there for you. Um, the other thing we can do to avoid liability on a personal account is let's keep the city information, city logos, city email addresses, city websites off of the personal accounts, right? It's one thing if you want to say I'm the mayor of this town and these are my personal views and they don't represent the city, but don't go putting the city logo and the city email, and you can contact me at my city email address, right? I mean, I think that starts to look a little bit more like it's a government account. And even though the focus for the test is authority, the court does tell us we're going to have to look at some of these things to figure out the answer here. And these are going to be fact intensive. And what that means, that's code for, lawyers don't have super clear answers all the time. Fact intensive is when the court tells us that. So I think those are the big picture things that we learned from the case. But the other thing I'll just say, the last thing I think is really important for listeners to understand is you want to be working with your municipal attorneys, my members, to develop policies and to make sure that they're updated after this decision, to make sure that all employees are trained on it, because it's not just the elected officials that this applies to. Obviously, the case was a city manager, but this could be really any city employee. So we have to make sure we're doing the training so that the city's not on the hook for liability.
No, I do think, this is one of those cases that municipal leaders must recognize that, once they raise their hand to say, I swear that I will follow all the rules and regulations and accept the role of mayor, council member, city manager, any city staff, that they are always, in a sense, on duty. And taking pictures of your food, yeah, that's something you should be able to do on your personal, because I have two phones. And the other phone, anything you do that is paid for by the local government pretty much becomes, quote unquote, could be considered city property and city voice. So the National League of Cities and our other partners, NACO and others, we really are working to educate our members about that, this case, and how it would impact their role every day. So I appreciate that. And it probably, this is one of those things that local governments probably said, you know what, it's okay that they clarify this, because in this environment that we're in plain talk, Amanda, it really is impacting us. And this is not a legal interpretation. And these comments are not legal the way I'm saying them. These really are big cases that are impacting our cities. Now, there's another one that perhaps the largest case of the term of the Supreme Court, and that was Looper Bright Enterprises versus Raimondo, the case that overturned what is called the Chevron deference. So talk to us about what is Chevron deference and how will the decision change the types of federal regulations that ultimately impact local governments and impact our ability to make decisions and implement programs. Because again, it sounds simple to most, but for our members, I really want them to know about the Chevron case.
This was a really big case. It's also a little bit wonky, so I'm going to do my best to sort of talk a little bit about administrative law with non-lawyers, which is always dangerous.
Well, the questions I will ask you and the way in which I will reinterpret them, any first grader will be able to understand it. So don't worry, I'll ask you some follow-up.
All right, perfect. Chevron is the case that was overturned, and that's a decision from just about 40 years ago that said if a statute was silent or ambiguous, then courts must defer to any reasonable agency interpretation of that statute. So what that case did for the last 40 years is it gave agencies a lot of power. because, I think you guys know this better than most. There's a lot of holes and gaps and ambiguities in congressional acts. And some of that's by design. Some of it's because it's just impossible for Congress to foresee every single scenario that might play out when they're writing these statutes. So, for the last 40 years, the way things have worked is agencies are the ones that really fill in those gaps with their expertise, technical and scientific expertise. And they explain those ambiguities. And then courts have just had to look at it and say, okay, that's reasonable. So, we are going to agree with the agency. And that's basically how it's worked. So, fast forward, the Supreme Court this term, as you said, a really big case overruled that Chevron decision in Loper Bright. And what the court said was it's the job of courts to interpret what the law is, not the job of agencies. And so, under the Constitution, courts have to decide what the best reading of a statute is, even if it's ambiguous, even if an agency has technical expertise. The government, the federal government that was arguing in favor of keeping Chevron and the dissent both said we have to keep the rule for the sake of uniformity. And we have to keep the rule because experts are better suited to sort of interpret these technical aspects of the statute. The court rejected that. So I think, one thing to understand about this decision, I think that the first thing to understand is what this means is courts will have more power, agencies will have less power. I mean, that at its sort of most basic form, that I think is the takeaway. But I think there's more here. So I think, the dissent and the federal government were arguing for this idea of uniformity in the law. And the court said that's not enough of a reason to keep a statute. And what it actually said was there's little value in imposing a uniform interpretation of a statute if that interpretation is wrong. So what that means for cities is a court in Illinois could interpret a statute one way, and a court in Florida could interpret a statute another way. And, we're going to have to live with these different rules for cities based on geography, unless and until that particular issue makes its way up to the Supreme Court. But I don't see how the Supreme Court's going to be able to take up every one of these issues, certainly not right away. So there's going to be a little bit of sort of whack-a-mole with these rules based on geography. So that's going to be, I think, a challenge for us as national organizations to make sure our members are educated. The other thing that this means is we aren't deferring to experts as much in the agencies, but the court did say, courts should still, and they're still free to take those expert agency interpretations into account. They just can't fully abdicate their role as courts. They can use that as persuasive authority and as weight, but they're not going to just say what the expert says goes. I think in terms of how this is going to impact cities on the ground, a less powerful administrative state, less power for agencies means those agency regulations are more likely to be struck down. Now, cities are often regulated by agencies. And so in some circumstances, striking down those regulations may benefit cities. And certainly if a city wants to challenge an agency regulation, this will be helpful because the court doesn't have to just defer to the agency. On the other hand, there's going to be some scenarios where cities would prefer the agency regulation. And I think in some circumstances, environmental regulations come to mind for a lot of cities. I think courts are going to be more likely to strike down environmental regulations. And I think the question of whether that's good or bad is going to come down to the specific regulation. It's going to vary from community to community based on demographics and geography and politics and other factors. So some folks might think it's great that it gets struck down and others might not, right? And then I think the last thing I'll say about it that I think could be a plus for cities is we've seen a lot of back and forth on agency regulations when administrations change, right? So you have the Obama administration says the rule is X, and then the Trump administration says the rule is Y, and then the Biden administration comes in and says, no, it's actually Z.
You're talking about PFAS probably when you say that.
I'm talking,
just generally, but examples. I'm just giving you an example. Go ahead.
That's definitely an example. And cities obviously follow those rules. They make efforts to comply with them when they come out. And so I think it can create this feeling of whiplash for cities and city leaders as they sort of get everything in place to start following a rule, and then it changes 4 or 8 years later, however long later. So I think what this decision will do, and we'll have to see how this plays out, is we'll see a little more consistency, because the court is ultimately going to be the one that says what the statute means, and then the agency can't go back and change that. Whereas before, an agency could change a prior agency's rule. That said, obviously court decisions can change too. This case involves overturning a court decision. So, court decisions are not, immune from that, but I think we will see a little more consistency as a result.
No, I do think the Chevron case is a major case for us to track and follow. And we're going to work to make sure our members understand the implications. I think that oftentimes when we see, the courts are going to make the decisions and not professionals, it does cause us concern. But I do think, as you define, the consistency piece is probably one of the value adds, if you will, of this case. But it's still for us, the local authority, local decision making. But having real guidance is also very helpful, and that it doesn't change with the political winds. But we're going to track that, because I'm pleased to hear that there is going to be some consistency, though. So I have one other question, and I want you to think about the future, because I don't think when I took this role over a decade ago that we would have thought the Supreme Court or any courts would have such an impact on municipal services, our social media, any of those kinds of things. As we look forward to the next court, what are the court type of cases you think local governments should be looking out for? Have you heard anything in the hallways? Is the docket going to be probably busier or not? What do you think about as we look to the future?
I think the term blockbuster gets thrown around a lot as it relates to the Supreme Court, not the
blockbusters.
90s. Not the 90s.
I was going to say the video stores, because you're making me think back. On Fridays after
Exactly,
work, I go and get my card and get
not that kind of blockbuster, but you hear that a lot. Oh, this is a blockbuster term. I think whether next term is going to be a blockbuster sort of remains to be seen. The court has filled out about half of its docket. And then what it'll do is it'll take cases in the fall to finish up the rest of the term. So we do have, I think, a good sense that there are several cases that the court has already accepted for its docket next term that are going to be relevant and important to local governments. And I'll just mention two here. The first is a ghost gun case. So Garland versus Vanderstock. This case involves the Bureau of Alcohol, Tobacco, and Firearms regulation involving ghost guns. And I think your listeners, I'm sure, know this better than most. These are firearm parts kits that folks can just buy from the internet, put them together in anywhere from 15 minutes to an hour or two, and you get a little YouTube video to do it. The problem with them is there's no requirement for background checks, and there's no requirement for serialization. And so the ATF stepped in and said, these ghost gun kits need to be regulated in the same way as firearms. And so they need to be subject to serialization, and they need to be subject to federal background checks. We've seen, I think, some pretty significant public safety concerns with ghost guns, allowing minors and felons and other folks that would be prohibited from owning guns under federal law obtaining them. And then we've seen, I think, some pretty significant roadblocks for law enforcement in trying to investigate violent crimes. If a gun lacks a serial number, it's much harder to solve that crime. And so I think what the ATF is trying to do here is close a loophole and just kind of make everybody play by the same rules. It's not saying that these ghost guns, as they're called, obviously that's the sort of just colloquial term, but it's not saying they don't exist and you can't manufacture these kits. They're just saying you have to play by the same rules as the other firearms manufacturers, the makers of these kits say they don't fall under the Congressional Act, and therefore the agency, and we were just talking about agency, authority, the agency has exceeded its authority. So the question for the court will be, this is not a Second Amendment case. This is a sort of statutory case, an agency authority case, and the court's going to decide if this ATF regulation is valid. If it's not, then it's going to be up to Congress to pass a law, or hopefully, individual cities who want to pass a law. Because again, this isn't a Second Amendment case, so the court's not going to say something that says, well, nobody can have a law, requiring ghost guns to, have certain background check requirements or things like that. So I think that's a really important case to watch, and something that I think will be important to cities. The other case we're watching for next term is San Francisco versus the EPA. So another agency case. Actually, I hadn't really made that connection, but in this case, it involves a challenge by San Francisco to the EPA's issuance of a discharge permit containing ambiguous provisions regarding water quality standards. So San Francisco isn't challenging clean water. They want to comply. They want to comply with the Clean Water Act. The issue here is really about clarity in these permits. And it's really important for cities to know what their obligations are under the Clean Water Act, because even a negligent violation can result in really significant penalties that can be both civil and criminal, and they escalate. And so they're really just saying, we need to know what we are responsible for. We need certainty in order to comply with the Clean Water Act, which we very much want to do. I think local governments, absolutely want to deliver clean water to their constituencies. And this is just about knowing what is required of them and making sure that the EPA is required to put some clarity in these permits so that they aren't held accountable for somebody else's discharges, for example.
As I, interpret that and think about it for our members, two of the major issues that we are dealing with is public safety. And the ghost guns case could have an impact, positive or negatively, but yes, it could have an impact. And now it's before the courts defining, how those are being used or how you can use those. The other one is the built environment, climate, financial impact. And the San Francisco case is one of those that could have impact on our ability to regulate and provide quality water. And we want to do that. But I always say good policy from the federal government comes with money to be able to address those issues. So as my interpretation, not from a legal perspective, but from a policy perspective, and that's our goal here, Amanda, is to make our members understand that these cases really will have an impact. And we, as the National League of Cities and the local government legal center, we're monitoring. We want to educate our members about these cases. And so I want to first thank you so much, because I've already pinned you as America's municipal attorney. So when somebody introduces you from now on, that's your title. I'll even go bigger. International municipal attorney for all cities, towns, and villages in America. And you're really needed at this time, because National League of Cities, we really are recognizing that the courts are becoming more and more, in our eyes, policy makers for direction for municipal governments, federal governments, and other agencies. Not that we're totally happy about that, because we want local authority, but we also want consistency. And that's one word that you use. And I want to say thank you for helping to explain that. So CitiesSpeak subscribers, you've had a chance to get educated and really challenge your thinking around the courts by America's municipal attorney, Amanda Karras. So, Amanda, thank you again for being here.
This was a lot of fun. Thanks for having me, Clarence.
All right. I appreciate you.
Thanks for listening to CitiesSpeak with Clarence Anthony. If you like this show, let us know. Share this episode with your friends and make sure to subscribe. We're curious to hear what you think, what you want more of, and how we can improve. If you have feedback or an idea for a guest you'd like Clarence to sit down with, send us your thoughts at citiesspeakpodcast@nlc.org. Join us next month for a new episode. Like and subscribe here or wherever you get your podcasts. See you next time.